hearing in the appeal ZH Tanzania against Secretary of State for the Home Department.
Ms. Carrs-Frisk.
My Lord, before looking at some of the case law under Article 8 dealing with the best interests of the child, I'd like to look at the proper interpretation of Article 3.1 of the Convention on the Rights of the Child. You have that, of course, in Authorities Bundle 2, tab 43. We say that the ordinary meaning of the words of Article 3 is quite clear.
So where are we? I know we're in tab 43. Article 9.
Article 3.1.
3.1.
3.1.
Yeah.
So the best interests of
primary consideration.
Shall
be a primary consideration.
A primary consideration, not the primary, not the paramount, but a primary. That, in our submission, makes it quite clear that other considerations can be taken into account, and indeed that much, I don't believe, is now disputed. What is in dispute, as I understand it, is the kind of considerations that could be weighed in the balance against the best interests of the child. I understand Mr. Gill's submission, supported by Ms. Dodson, to be that the only argument that could weigh against the child's best interests is some form of rights-based argument, i.e. not a general public interest argument, such as the interests in maintaining immigration control. That seems to us to be where the debate really lies. Well, our first response is simply looking at the wording of Article 3.1. That article makes clear what the decision maker must consider and must give significant weight to, i.e. the best interests of the child, but it does not purport to exclude any other particular considerations.
Do you accept the way Jane McAdam put the point in her article? You recall that she says the first thing you must do is to ascertain what are the best interests of the child. And then she says you assess the strength of the other considerations, and she doesn't put any detail into this, just the others, whatever they happen to be, asking yourself the question, do they prevail? Understood that the best interests of the child are or as she puts it, a primary consideration. So she uses the indefinite article, which we find in 3.1,
yes,
but she expresses it that way. So she doesn't exclude anything, but the real point she's making is that you've got to see that whatever that other bit is, or bits, they don't outweigh the children's interests, they being a primary consideration.
Can I answer that question in this way? Certainly, yes, it is accepted that in order to give meaning and effect to Article 3.1, the decision maker clearly at some stage has to form a view as to what the best interests of the child are, and insofar as there's any question of those being outweighed, he or she must also form a view as to what other considerations come into play and as to whether they indeed outweigh the best interests of the child. My only slight caveat is as to when in the analysis you do that. I know that there is a concern on the part of those behind me about inevitably boxing decision makers in so that you have to start at a certain point. Now, maybe one can see that when a letter comes in containing representations to the Secretary of State about Article 8, all sorts of factors will be put forward, and the decision maker may initially look at everything in the round and may at a later stage get to the point where he or she says, clearly the interests of a child are at stake here, I've now got to form a view as to what the best interests of the child are, and then look at whether there are any factors that could outweigh that. So it's the same, I accept Ms. McAdam's analysis with the only caveat that one shouldn't say, well, that has to be inevitably the very first task that the decision maker carries out in any case.
When you arrive at the stage where you're making the determination, whether or not you engage in an open evaluation of the various factors, when you finally arrive at the stage that you're going to make a determination, would you be comfortable with the formulation that there is a presumption that the best interests of the child be followed unless there are sufficiently potent countervailing factors to displace it?
I have a little bit of nervousness as to adding the word presumption, my lord. May I say, and it may be that there is no real difference, plainly what is intended is that there must be sufficient countervailing factors to outweigh the best interests of the child. That may mean pretty much the same thing, but I would be concerned about assenting to the notion that it is inevitably a presumption.
It seems to be difficult not to recognise that if you consider that there have to be sufficiently strong countervailing factors to outweigh what is in the best interest of the child, it seems to be difficult to disavow a presumption.
My lord, I see the difficulty, and I certainly agree, as I've said, that once you know what the best interests are, you have to then carefully look at whether there are factors that could outweigh those
Mr. Gill has
interests.
invited us to give clear guidance as to how the structured approach to this question should be. And on one view, it would be clear to those who have to take these difficult decisions, if we were to say that there is a presumption that the best interests of the child, once they're determined, that's not always an easy determination to make, but once they are determined that they must prevail unless the presumption is displaced.
My lord, I would be content with the formulation as put to me by my Lord Hope, subject to the caveat I entered. As I say, it may be that there's very little, if anything, between that formulation as per Miss McAdam's article and your lordship's.
Yes, thank you.
I'm sorry I can't improve on my answer to that question.
If one looks at it slightly differently, in a way which is perhaps more familiar, if one said that this was a situation where all relevant factors must be taken into account, but a primary and very commonly very weighty consideration would be the child's best interest.
Yes, I would be.
And it follows, therefore, one wouldn't necessarily be asking, are the other factors sufficient to outweigh, but whether one introduces the formal language of presumption, which suggests that the question perhaps is always the same sort of question in every case. That there might be situations, I put one earlier, where the best interest of the child, a very young child, if one looked at them, would be to stay here, just on the basis that the United Kingdom's a good place to live. But nonetheless, one wouldn't have thought that was a very weighty consideration if the child was a foreigner, if in reality this was a flagrant breach of immigration control, or if there's been some criminal offence committed.
That's certainly a very important point that I would wish to come on to. And of course, yes, to some extent it depends on what one then means by the best interests of the child and how broadly one takes that concept to be. If one takes it to be very broad, yes, then it might be said, because a child will get better schooling perhaps in this country, it inevitably means its best interests will lie in staying here. But that of itself, we would say, could not of itself mean that there is a presumption that the child and his or her family must be allowed to stay here.
So maybe very frequently a very weighty consideration would be something you'd
Yes,
be happy
or a
with.
consideration of the first order, certainly, yes.
I would have thought the attraction of the approach that Jane McAdam adopts, which is based on the case of Wan, I think, the Australian
Yes,
case,
of which
is
we
it doesn't
have a
actually
copy,
use the word presumption.
No.
She's quite careful, I would have thought, not to do that. But she does have a kind of structure to the approach.
And, yes.
And inevitably, she puts, I know you disagree with this, but she does put ascertaining the best interests first, because you really need to know that before you start weighing in the balance, because this is always going to be a primary consideration.
You certainly need to know that first before you carry out that particular balancing exercise. But it is important not to lose sight of the fact that we are going to generally be concerned in these sorts of cases with a number of factors, other family members too. I mean, one may have a child in the case or several, and they will be very important, but we're also concerned potentially with other family members and a large number of factors that will undoubtedly be placed before the decision maker in the first instance. And as I said, we're simply concerned that the decision maker must be allowed to take an initial overall view, simply sizing up what the various factors in play are, and then at some stage it may become absolutely apparent that the best interests of a child or children will need to be identified. And of course that must then come before you weigh any considerations that go against their best interests.
Well, I think we all recall the last sentence, I think it is, of paragraph 12 in the Lebanon case, where Lord Bingham said it's not possible in this field to have hard and fast lines, any bright line rule or something of that kind. So I think everyone appreciates that problem is bound to vary from case to case. But this case does have a feature which Lord Mance has mentioned and which I know you're coming to, which is the British citizenship.
Yes.
And is it right to say that that puts this case into a somewhat different category from the long stay individual who can't claim British citizenship but has established a position in this country? Is there a difference between them, and if so, what is
My
it?
Lord, our position is that of itself, British citizenship, does not put this case into a special category. I will certainly come on to try and make that good based on the case law we have.
When you say not a special category, I mean, you're not suggesting that it has no weight at all.
Certainly not, my Lord.
No, quite.
I am really going back always to Lord Bingham's reference to how one can't have bright line rules, and also to the general approach of Strasbourg, not just of Lord Bingham and the House of Lords in the many Article 8 cases we've already had, but of Strasbourg, whereas it seems to us Strasbourg is very careful not to set up a hierarchy of criteria, other than in the one special case of children, where it has now moved towards, or has got to a place where it does say expressly that the best interests of the child is a particular consideration, a primary consideration. But the general approach is very much to have a list of factors with no hierarchy. And as I think I said yesterday, one can see the sense of that because there is a danger in setting up a hierarchy or isolating one factor over others. And the danger is that you may then over-focus on that factor and actually lose sight of other factors that may be as important or more important in the particular case. But staying, if I may, for a moment with Article 3.1 and Mr. Gill's point there that you simply cannot look at general public interest factors, he invites you to look at the drafting history of that provision, which he says supports him. Well, our first response to that point is actually the words of Article 3.1 are sufficiently clear. If you give them their ordinary meaning, you get to the position that we advocate, i.e., any factor is potentially relevant, and there is simply no need to go to the drafting history. But in any event, if you look at other material that has considered the drafting material, that is other material than that which you were shown yesterday, one gets a somewhat different picture. One gets a picture that suggests that general public interest factors can perfectly well be taken into account. I have in mind here a commentary on Article 3 by Mr. Michael Freeman, which is in the third authorities bundle at tab 73.
Is he not entitled to the dignity of professor?
I am sorry he is, and I really ought to know that, as he taught me at one stage, and I apologise to him and to everyone who knows him.
Perhaps he wasn't a professor then.
He's always
that
been
is-
No, he
professor.
certainly was then, but I think sometimes publishers tend to blank these things out, and I know sometimes they take away our titles and use first names and
Yes, I am very
everything
sorry
else.
because I was very pleased to be citing my old teacher, and now I have actually done him down, Professor Freeman.
Yes. I think we have an autobiography as well, which probably tells us that he is a professor.
Yes, I'm sure I know he is. Could we go, please, to page 25? It's the beginning of chapter 3. In fact, I don't think one sees the page number on that particular page, but it does come
Yes.
after page 24.
Certainly.
He looks at the origins of Article 3.1. Article 3.1 is pivotal to the whole Convention. It lays down the general standard which underpins the rights set out in subsequent articles. Principle 2 of the 59 Declaration stated, and then he quotes that, and you get the bit at the end, best interest of the child shall be the paramount consideration. The first draft of the UNCRC included this principle in full. Most significant is the standard upheld by this principle. The child's best interests are to be the paramount consideration. They are not therefore one factor among others, they are not even the first consideration. Under this test, they are not merely the most important consideration, they are simply determinative. Some delegations were uncomfortable about this. As a result, an alternative draft was submitted in 1980 to the Working Group of the Commission on Human Rights, whose responsibility the drafting of the Convention was. Then you get the formulation with a primary consideration. This revised text was first discussed in 1981, and though there were reservations, it was adopted. There was no discussion about it again until 1988. At that point, there was a proposal to substitute D for A in qualifying the words primary consideration. Such an amendment was rejected. The only amendment agreed to was the addition of a reference to legislative bodies after administrative authorities. This addition does, of course, broaden scope of the best interest considerably, suggesting, as it does, that legislation ought to be accompanied by child impact statements. And then, linked to that, if you would, pages 61 to 62. Starting at the beginning of the second paragraph on page 61, if the child's best interests are of primary consideration, what is the difference between a primary consideration and the primary consideration? The use of the language a primary consideration instead of the primary consideration suggests that the best interests of the child are a consideration of the first importance among other considerations. They do not, however, have absolute priority over other considerations. In the deliberations over drafting, it was clear that some delegations were concerned that there were occasions in which there were competing interests, for example, of justice and society at large. These, some claimed, were of equal importance, perhaps even in the eyes of some greater importance than the child's interests. And then there's a reference to a medical emergency. If you go right to the end of the page, for Alston, A rather than the is there to offer the decision maker sufficient flexibility, at least in extreme cases where the interests of people other than the child or children may be allowed to prevail. Alston and Gilmer-Walsh believe the drafters wished to ensure a degree of flexibility in the application of the principle, not because they thought that the children's interests should not be paramount in some circumstances, but because the principle as contained in Article 3 was to be of broad application, and an approach that gave paramountcy to children's best interests could not be justified in all of the situations to which the article might apply. Now, naturally, we would home in here on the reference at page 61 to those among the draftsmen or women who were concerned that general interests such as justice and the interests of society at large might have to be weighed in the balance. Fairly clearly, it seems to us, those sorts of interests are precisely broad public interest considerations, not considerations based on impact on individual rights. And so it would appear that the drafters did have in mind that broad public interest considerations could come into play.
The examples given, though, of competition, as it were, between one and another are of individual rights, aren't they?
That is true, that example.
This is, and one can well understand that if it's a question of life and death.
Yes.
In the conjoined twins case and so on.
Yes.
But are there any examples of a case where somebody has said that the interests of society at large are of greater importance than the child's interests? Because it would be of great interest to know whether there were.
Well, the only example, and it's not very specific, is that reference to some delegations were concerned that there were occasions in which there were competing interests, for example, of justice and society at large, claimed of equal importance, perhaps even in the eyes of some greater importance. Now, that is as specific or non-specific as it gets.
Yes,
What about Una? I mean, I
Yes.
think my lord was actually thinking of specific cases.
Yes,
Cases.
has it been
So
tested?
sorry.
I mean, it's
Yes.
one thing to deliberate and then throw out an idea, but has it really been tested?
But
That's
the
I
whole
misunderstood.
essence of Una was that the interests of society at large could predominate, and the court cited Article 8, Paragraph 2 in general, which refers, amongst other things, to the general social and economic interests of the country. Admittedly, that's a case, as Mr. Gill says, of
Absolutely.
criminality, but nonetheless it said, it spoke in general terms.
It,
Well, let me
it did,
suggest
but there is a case. Yes, I'm sorry, Mark.
I was going to suggest another, I mean, I may be wrong, but it would seem to me a fairly obvious case. A woman comes in with a 1-year-old child in the back of a lorry, gains entry to this country as an obvious illegal, a month later is discovered as such. The child has absolutely no connection with this country at all, or indeed the mother, but it's obviously, instead of being sent back to sub-Sahara, wherever it may be, the child's interest, no doubt, would be to stay here and have all the benefits here. But one would have thought that there was indeed there an immigration control interest in removing the child.
Well, we would respectfully absolutely agree with that, and that is where the principle that the Convention is not about protection against disparity in social welfare provision is important, and I'll come on to that. And that's a principle that one needs always to bear in mind, we say, in this context, as no doubt in many others. In answer to the question about specific cases, yes, I was going to come on to one in a moment, if I may, which is called Da Silva and Hoogkamer against the Netherlands, which is actually a fairly recent case of the Strasbourg Court, which was a case of a non-EU, well, a Brazilian mother and a Dutch citizen child, where the general interests of immigration control were absolutely weighed in the balance by the Strasbourg Court against the best interests of the child. So that is a clear example in our submission of the Strasbourg Court adopting that approach.
Should we look at that case then?
Yes, would you like to look at that
Yes.
now?
Yes.
Of course. That is at Bundle 2, tab 53. So as I say, tab 53, you have the Brazilian mother, you have a daughter in the Netherlands with Dutch citizenship, and a proposal to remove the mother to Brazil. That was held to be incompatible with Article 8 And I would ask you to go to paragraph 39 on page 9. And it may be less dreary if I invite the court to just read paragraph 39 to yourselves first.
Yes.
And then paragraph 44 over the page is key. In view of the far-reaching consequences which an expulsion would have on the responsibilities which the first applicant has as a mother, as well as on her family life with her young daughter, and taking into account that it is clearly in Rachel's, the daughter's, best interests for the first applicant to stay in the Netherlands, the court considers that in the particular circumstances of the case, the economic well-being of the country does not outweigh the applicant's rights under Article 8, despite the fact that the first applicant was residing illegally in the Netherlands at the time of Rachel's birth. Indeed, by attaching such paramount importance to this latter element, the authorities may be considered to have indulged in excessive formalism. So what we get from that is that the court is plainly allowing the economic well-being of the country, i.e. immigration control, as a factor to be weighed against the best interests of the child. And so it is allowing that there could be circumstances where those interests of the state could outweigh the best interests of the child, but the court is saying in the particular circumstances of the case, that is not so.
Yeah. Well, I suppose if you go back to the first sentence of paragraph 39,
Yes.
if that's where the balance is to be struck, it's inevitable that you would take into account public considerations such as immigration control.
Yes. And of course, that sort of statement, the statement at the beginning of paragraph 39, one gets repeated over and over again in the Strasbourg cases that deal with this area. So it would be extremely surprising if those considerations were completely ruled out of play as soon as one is concerned with the best interests of a child.
Yes, indeed, but you do have to look at this particular case. I'm not dissenting from anything you're saying. There was no question of the child leaving in this case. There was no question of the child having to go or going. The child was being jointly brought up by mother and grandparents.
Yes.
So we're not talking about the constructive expulsion of a child.
No.
We're talking about the expulsion of a parent, when in fact the child could stay behind.
My lady, I accept that. I'm simply referring to the case really for the principle, and I hope to knock down Mr. Gill's rather stark submission that this sort of consideration can't even be looked at.
One might have thought, though, that actually forcing a mother to go back to Brazil, leaving her daughter behind, was actually worse than effectively saying that the solution to this problem is they should both go to Brazil.
Yes.
I mean, it's all very well saying live with your grandmother. That may be a very nice relationship, one hopes, but nonetheless, you're actually severing the critical mother-child
on the
relationship.
assumption that
Half a week with mum.
It may not be irrelevant that she'd left two sons behind in Brazil.
Yeah.
Can I just, the last sentence of paragraph 39
Yes.
is actually, if one's talking about presumptions, as Lord Kerr mentioned, it might be said that the court's putting the presumption a presumption of an opposite nature. Courts previously held it's likely only to be in the most exceptional circumstances that the removal of a non-national family member will constitute a violation of Article 8, where
That's where the immigration status was precarious.
was precarious
at the time.
from the outset.
Yeah.
Well, that's a point which was raised in this case by the
It certainly
tribunal.
was a point that was raised here.
Do we
And,
have the... yes, sorry.
No, I was going to say yes, and it is a point that is raised from time to time and referred to from time to time in these cases, and of course it has been the standard learning for quite a while that is indeed a very important factor.
Yes. But then you have to look at the last sentence of paragraph 44, which is a riposte
Yes,
to the point
excessive formalism.
where they say excessively formalism to attach such importance to this point.
Yes, and of course the Secretary of State, having borne all of this in mind, has indeed accepted, as we know, on the stark facts of this case, that what was described as the appalling immigration history of the appellant should not be such as to outweigh the best interests of the children in actually being able to stay here with her. So
And is that on,
there we are.
Is that on the principle that the sins of the parents, as it were, can't be visited on the children? Or is it something different? Because the argument, I think, as we heard yesterday from Mr. Singh, is that you can't attribute to the child or the children some attempts to evade the immigration rules that the parents have adopted. It would be quite wrong to punish them, as it were, for their parents' sins. Is that the approach you take?
I should not be taken to accept that a bad immigration history is irrelevant. But evaluating all the factors in this case, and particularly bearing in mind, as we have said in our printed case, that the children, of course, have been here all their lives for some considerable time, and that their contact with their father, which has been frequent, would undoubtedly be severely curtailed if they were to go to Tanzania. Taking it all in the round, it was thought right to concede that that decision could not stand.
I mean, you can't ignore the immigration history and whether there are breaches, and indeed there they are in paragraph 39 in this case.
That's
I mean,
right.
it's one thing to say you can visit the sins of the parents on the child, but quite another to say that it's simply irrelevant as to whether... I mean, of course, in many cases, of which ours is now by concession one, you know, it's well outweighed by the interests of the children, but it won't always.
No, absolutely. And particularly if you look at adults, one can well imagine situations where in relation to an adult partner who may face the choice of staying here or moving with his or her partner to another country, knowledge of the precariousness of the other person's immigration status may be highly relevant. It all really, again, goes to show how sensible it is to have a very fact-sensitive approach that looks at it all in the round, subject only, we would say, of course, to the concept of the child's interests being particularly important. May I also say about Rodriguez da Silva that it's notable that no special mention is made of the Dutch citizenship of the children, of the daughter, sorry. Now, clearly, the daughter's best interests is a highly important factor in the case, but as I say, there's no specific reference to her citizenship that I've been able to find.
But there's no suggestion of her being expelled, so at all?
No.
Required to go?
No, that is true too. That is true too.
No
that is
question
not
of her-
specifically explored.
In fact, it's stronger than that because there was no question of mum being able to take the child with her.
Right.
Yes.
Yes, I mean, the tie would be broken, I think, that was the point, but there's no suggestion that she was going to be
I
taken
take
abroad as well.
that point. Yeah. Going back, if I may, for one moment still to Article 3.1
Yes.
of the Rights of the Child Convention, reference has already been made to the article by Jane McAdam, and we've made our point that certainly up to a point we agree with what she says there about the need at some stage to identify the interests of the child and then look at other factors. There is another point that in our view supports the submission that it must be possible to look at broader public interest factors, and that is to be found in the Convention itself, Article 9. The Convention was in Bundle 2, tab 43. Article 9 is the article that says that states parties shall ensure that a child shall not be separated from his or her parents against their will, except when competent authorities subject to judicial review determine, in accordance with applicable law and procedures, that such separation is necessary for the best interests of the child. That, on the face of it, of course, is a very strong obligation, but if one then looks at paragraph 4, one sees that it is nevertheless evidently contemplated that there could be situations where such separation occurs, even though it would be unlikely that it would be in the best interests of the child, such as where the parent is imprisoned, exiled, deported, or dies, including a death arising from any cause while the person is in the custody of the state.
Reading through this particular provision, what is it really getting at? It's saying, should that event occur,
Yes.
certain things need to be done, isn't it?
Yes, it does say that. So I can't go so far as to say that it is formulated as an express exemption to the obligation in 9.1, but nevertheless it clearly contemplates, by necessary implication, that such situations will occur by making provision for them. And we would rely on that simply to say, well, it appears that the Convention itself contemplates that other factors could come into play which might necessitate separation.
Well, like extradition or prison.
Yeah, exactly.
Deportation is expressly referred to.
Is expressly referred to, that's right. So it's another pointer towards Mr. Gill's argument, his stark argument, being wrong. But I should probably also look at paragraph 86 of General Comment number 6, which Mr. Gill paid particular attention to. That's in Bundle 3, tab 62.
We're on page 22 or 23, aren't we?
Yes, page 23.
It's 23, paragraph 86.
Yes, paragraph 86. We make the obvious point that this comment is made in the very particular context of unaccompanied and separated children who are noted in paragraph 1 on page 5 as being in a particularly vulnerable situation. That's the very first sentence of paragraph 1. So one can see a particular concern about returning children in that position. In any event, it would appear from reading paragraph 86 that the committee may here be offering more of a view as to what ought to happen, in its opinion, than offering a description of how Article 3.1 of the Convention must be interpreted. As I've said, on the ordinary wording of Article 3.1, there would appear to be no limitation on the sorts of factors that could be taken into account when you weigh up the child's best interests and other considerations. there's also a problem about the reference in paragraph 86 to rights-based considerations. What exactly does that mean? Because one sees that, of course, they offer as a possible relevant consideration that the child constitutes a serious risk to the security of the state or to the society. Now, those, it seems to us, are classic public interest considerations, similar to the sorts of considerations we see in the Article 8 cases about people being convicted of serious crime and therefore being a risk, may have to be removed on that basis. And yet that is supposed to be a rights-based argument. So it's a difficult distinction on any view.
Would you say, I mean, the question arises whether one would say some of the factors in Article 8.2 of the Human Rights Convention are not rights-based on this analysis. It's, one suspects that they are actually all rights-based if you look at the other international conventions.
The right of the state to control the entry into its territory of aliens and so forth. Yes, one can certainly...
But also the
and rights of individuals.
Public safety and economic well-being. There are covenants which cover exactly that sort of state obligation to its citizens.
Yes. One can certainly put it that way, and one finds support for that, as I say, in the fact that it's here recognised that risk to the security of the state or to the society is apparently rights-based.
It looks as if it's drawing a distinction between physical risk and economic risk.
That may be so, yes.
And you would say, well, that's not a logical
Indeed it isn't.
or apparent distinction to draw.
I would say that, I was going to put it very colloquially, it's not a distinction that makes sense, with all respect to this committee. And I was going to say there's support for that in the UNHCR guidelines on how you determine the best interests of the child. But I have to say that with some qualification, as it turns out. If the court would please go to those guidelines, it's bundle 3, tab 64. What is helpful is to be found in a passage we looked at yesterday. It's page 15, the 2 bullet points at the top above paragraph 1.2.
Yes.
Certainly supports the idea that the child's best interests are not always determinative.
It's in fact drawing the sort of distinction that we were talking about yesterday, where Miss Dodson raised Section 1 of the Children Act 1989.
Yes.
In that when you're actually directly concerned with the future upbringing of the child and the relationship between the child and the particular adults with claims upon that child, well then the best interest of the child is the tie-breaking
Absolutely.
consideration. So it rules on or determines. But when you're dealing with other things that affect children, it's something you take into account.
It's different, and when you have a broader public interest that is involved. Yes, quite so. Thank you, my lady. Now, then you do have a section 3.6 on page 76 that is headed Balancing Best Interests of the Child with
Sorry, where are we
Rights
now?
of Others.
76.
Page 76. Where one sees, they say, the interests of a child can sometimes conflict with the interests of other persons or groups in society. The general principle contained in the CRC provides that the best interests of the child shall be a primary consideration. The Convention does not, however, exclude balancing other considerations. That's right. Which, yes, I was rather disappointed when I got to this page. However, I would say, as I said in relation to paragraph 86 of the general comment, that it looks as though this is really a prescriptive view, a sort of this is how it ought to be, rather than offering the proper one and only interpretation of Article 3.1 as a treaty provision. It's really suggesting that, whatever rights-based considerations may be, they are the ones that are likely to trump the best interests of children. And again, we have no definition, apart from an example of what is meant by rights-based. If you see the example in the next paragraph, it's about placing a child with tuberculosis in a foster
Well, it does
carer's
depend
family.
very much on what the writer is thinking about, and one gets the impression that the writer wasn't really thinking about the kind of context we're looking at the issue in.
Yeah.
At first sight, it's a very obvious kind of point to make, that there are other people who might be physically affected by what you're doing.
Yeah.
Conjoined twins, another example of that. And,
It's simply not exactly addressing what we're concerned with here. And overall, I would say one certainly could not use this comment, or indeed the comment in paragraph 86, as a basis for saying that on its proper interpretation, Article 3.1 of the Convention rules out any consideration of public interest factors. And that's leaving to one side that one may in any event say that they too are about rights.
Just help me.
Yeah.
Obviously, one pays respect to informed and learned commentators, but does this have any status as an aid to construction at all in international law under the Vienna Convention?
At best, it would possibly have some persuasive force, but certainly no more than
persuasive
that.
force
Persuasive
in the sense that Professor Burroughs' writings on restitution have, or more than that?
Not more than that, certainly not more than that.
It's not a sort of evidence of opinio juris or state practice, is it?
No.
I just wondered whether they had any role in issuing guidance. It's a formal guidance. Does the convention itself contemplate guidelines?
That, I'm afraid I'm going to have to check. Certainly the Committee on the Rights of the Child, of course, has a particular role.
But not actually a lawmaking role.
Not a lawmaking role, but certainly its views.
Well, one gives them weight because they're informed and
I accept that.
It's a bit more than that, because there's a reporting mechanism.
There is a reporting mechanism
And,
too.
it's part of the obligation under the convention for each country to report on their implementation of the convention, and then the committee gives them marks out of 10, basically.
Yes.
And does it lead to the general comments? I mean, that's an annual critical comment, really, on what's going on, isn't it? With reference to
It's similar, as I'm saying, similar to what the Human Rights Committee does in relation to the ICCPR, for example.
But it doesn't, the interesting question, maybe it doesn't arise, is how far that actually creates law. One has lots of reporting obligations to the European Commission, and it issues reports, but it doesn't always get it right.
No, well,
And sometimes it's pushing the boundaries in a way which actually goes further than the court would go.
Indeed, my lord. And as I say, I certainly accept that such commentary can be persuasive in some cases, maybe very persuasive, but it's no more than that. Yes, the committee does have a particular status in relation to the convention, but even so, one doesn't get further than really giving it such weight as is appropriate in the circumstances.
Is there any difference between the status of general comments and guidelines, or do they both fall into the same category?
My lord, I would say that the general comments do have a particular relevance, as I've accepted, because of the committee's particular role in relation to the Child Convention. So it may be on that basis that the UNHCR actually has a somewhat lower status in this particular field, but I wouldn't want to base my submissions entirely or even majorly on that point, my lord.
But it is an important point, isn't it?
Yeah.
Because you'll correct me if I'm wrong, but the impression I'm getting from the UNHCR document is that this is the UNHCR saying, in relation to the children for whom we are responsible, this is how we think we should apply the Convention on the Rights of the Child.
Yeah.
That's what it's doing. It's not telling governments what to do, except as partners in looking after refugees and the like.
Yes.
To that extent it is. But it's not giving authoritative guidance on what the Convention
It's not
means.
giving guidance on exactly, and that's the point I made earlier, or sought to make earlier. It's not saying descriptively, this is how you must interpret the Convention, because this is its true and only interpretation. It is really more of an, this is what ought to happen, expressing a prescriptive view.
It uses the expression soft law at page 15. There's a review of what it describes as other relevant legal sources, which include the comments and various other things. I think it recognises it doesn't have the same status as the international and regional instruments to which it refers.
No, indeed.
These children are, of course, not in any way the responsibility of the UNHCR.
No, absolutely not. No.
They're not refugees, they're not stateless.
No.
They're British citizens living in their home country.
That is right, my lady.
We're just going back very briefly to paragraph 86 of the general comment number 6.
Yes.
Leaving to one side the question of rights-based arguments, and it is there stated that matters such as relate to general migration control cannot override best interest considerations. What significance, if any, should that have on our deliberations in this case?
Well, my lord, our submission is that at most what you have here is the committee expressing a view as to what ought to happen in applying the convention in relation to children who are unaccompanied or separated. And so that when one is considering returning such children, and when it isn't in their best interest to do so, the committee is, if you like, recommending that general migration control should not be an answer, should not be considered as outweighing the best interest of the children. It's perhaps difficult to read the phrase general migration control as other than referring to pretty much what it says, immigration control.
But it is very specifically, general comment number 6, separated, unaccompanied and separated children.
Absolutely. It's very much in that context, and one mustn't lose sight, as I said, of the particular vulnerability of such children, which is what this whole comment is about, starting with paragraph 1, where that point is made. So one certainly can't derive from that any general proposition that you can never weigh general migration control or the interests in that against the interests of children. But at the end of the day, of course, one should interpret the treaty provision in question, Article 3.1, on its ordinary meaning, and then, of course, one needs to translate that into the jurisprudence of the Strasbourg Court and to see how that has played under Article 8, because, after all, we're not directly concerned with the Convention on the Rights of the Child. And that's where you get cases such as Rodriguez de Silva, which I hope has made the position clear.
I mean, are you going to come back to the Strasbourg cases or particularly or not? I mean, I'm not
Yes,
inviting.
I was going to.
Okay. I mean, I'm just wondering, is there any which, I know you've shown us various passages which talk of nationality as a factor, rather than in every case definitive. But I mean, is there actually a case on its facts where Strasbourg have said it's okay to send, or with the inevitable consequence of a decision where the national children will go abroad?
There are two commission decisions
I see.
that I was going to come
I
on
see.
to. I don't know. I'm happy to do so now or to get to it.
Well, no,
later.
I mean, as you like. I mean, I thought this case was all about citizenship rather than children generally, but
It was as per the agreed statement of facts and issues, but we were content when we saw the appellant's case to deal with the best interest point because it seemed at least closely linked, although I will make the point that so far as the principle of equality is concerned, that is a very different and potentially complex topic which the appellant really should not be able to raise for the first time ever in these proceedings in the printed case. But that's a different point.
Well,
I'm entirely in your
I
hands as to...
think we probably, if you just follow your course, I'm sure
Yeah, no, absolutely.
Lord Brown will be
Okay.
content with that, if you just take us through the line you've planned.
I'm grateful, yes. Well, I was then going to go to the Nidiker case, the Privy Council case, which you have at Bundle 1, tab 18, where these issues were fairly directly touched on in the speech of my Lady Baroness Hale.
It's like feeling that's water under the bridge now, but there we go. Because the case was the case went off on other things, yes.
Yes. That was a case about a Nigerian doctor who brought various constitutional claims because of a failure to renew his work permit and subsequent detention with a view to deportation. But of particular relevance for our purposes is the position of his daughter Faith, who was a citizen of Trinidad and Tobago, which is the country we're concerned with here on the appeal to the Privy Council. Now, my Lady Baroness Hale then dealt specifically with her position, and one sees from paragraph 70 on page 558, paragraph 70, that the crucial right claimed on behalf of the daughter was her right under Section 4C of the Constitution as a citizen of Trinidad and Tobago to respect for her private and family life. It is argued that the minister was bound to take her rights into account before making the order to deport her father. And then I would refer you, if I may, to paragraphs 74 to 77, including the first sentence of 77.
You'd like us to read that?
I'd be very grateful.
I think you agree with most of that, don't you?
I do.
Yes, I thought you might.
I'm hoping everyone else will.
Yes. This is down to first sentence of 77, was it?
Yes.
Yeah.
So, rights under the Convention on the Rights of the Child, not absolute. Interests of the children, not the paramount consideration at all times. You cannot conclude that no foreign parent of a citizen child can ever be deported, paragraph 75. And then at paragraph 76, a reference to how it might be that it would have been possible quite legitimately to deport the father, with the consequence that the daughter would have gone with him to Nigeria or wherever else. Between letters E and F at 76, the benefits to her of being brought up in Trinidad and Tobago rather than Nigeria or wherever else her father could go might very well be insufficient to outweigh the legitimate state interests in deporting him.
Yes.
Going back then briefly to the Strasbourg cases, you have of course seen the Una case many times, and it may be that all I have to say about that is just to remind the court that in paragraph 54,
Tab 54.
it's tab 54, and I was thinking of paragraph 54, where the court makes the standard reference to the state's entitlement to control the entry of aliens into its territory. Thus, by implication, we would say allowing for concerns about immigration control to be considered, and not only considerations that weighed heavily in that case as to the criminality of a person who is to be removed. So it's broader than that. It may also be
Sorry,
worth...
which paragraph were we looking at in Una? I was got behind.
That was paragraph 54 of Una.
And it was the first sentence,
First
I think, wasn't
sentence, yeah. It may also be worth going back briefly to the Maslov and Austria case at bundle 3, tab 55. We've looked at it, of course, but I wanted to emphasize paragraph 70 on page 20, tab 55, where the court says, the court would stress that while the criteria which emerge from its case law and are spelled out in the Gultief and Una judgments are meant to facilitate the application of Article 8 in expulsion cases by domestic courts, the weight to be attached to the respective criteria will inevitably vary according to the specific circumstances of each case. So that provides some support for our notion that the court is reluctant to set up a hierarchy of criteria. Although, of course, as you've seen, if one goes to paragraph 82 and 83, the court certainly does mention specifically the need to have regard to the best interests of the child. But it's certainly not being said that those interests can never be outweighed by broad considerations of public interest. Moving on, if I may, to the Neulinger case, which is at tab 56, next tab. That, of course, is not an immigration case, although Mr. Gill relied on it quite heavily. And I just wanted to point out, because I thought it might possibly have got lost yesterday, that if one goes to the key paragraph, paragraph 134, on page 38, one sees that the court certainly allows, even in that context, essentially a family dispute, that the child's best interests may, depending on their nature and seriousness, override those of the parents. Sorry, I put that the wrong way around. The court is allowing that the parents' interests may override those of the children. I put it the wrong way around again. I think what I'm really trying to convey, not getting it right, is that it is accepted that the child's best interests may be overridden, even in that particular context of essentially a family dispute.
You might be interested in a case which I saw was referred to in something we were looking at earlier, which appears to be quite relevant. This is a Nigerian, it's a case called Solomon against the Netherlands, a Nigerian who came contrary to immigration control, I think, to the Netherlands. I haven't read it very thoroughly, but had a daughter with Dutch nationality. Nonetheless, interest of the protection of the national economic welfare outweighed those of the applicant and his daughter, and the Dutch courts refused to hold that there was any right to remain in the Netherlands. There was complaint under Article 8 to the court, which was rejected as inadmissible.
I'm very grateful for that reference. Is it possible to know the date?
It's 2000. We can give copies. There's, I think there are 3. There's another
Yes,
one.
I'm grateful, my Lord. It sounds as though that is relevant and
Pass it round.
and supports our argument.
3 more.
Yes. Well, my Lord, may I then, with gratitude, incorporate that reference into our submissions? It looks as though it does indeed support the points we have made.
There's a statement on page 6 about whether removal or exclusion is incompatible with Article 8 depends on a number of factors. Extent to which family life is effectively ruptured, the extent of the ties, whether there are insurmountable obstacles in the way of the family living in the country of origin of one or more of them, whether there are factors of immigration control, e.g. history of breaches of immigration control or considerations of public order weighing in favour of exclusion.
Yes.
And this was the case, it was cited in another case, as I said, that you... And you see that the child was Netherlands nationality on page 3 of the footnote.
Page 3.
Yes, thank you, my Lord.
And of course, this is a case of establishing family life when your status is precarious. That's part of it. However, it wasn't a primary carer. It wasn't a constructive expulsion of the child.
I see, yeah. Yeah.
I don't know of any case which has involved a constructive expulsion of the child. Maybe the two...
Apart from Nidica.
Yeah, but it didn't, of course. It didn't happen.
It didn't, no, but that was the
Never got
proposal under
anywhere near
consideration.
happening, in fact, yes.
No, but that does seem to have been the assumption of looking at the facts.
So this child was going to stay there in the Netherlands, what was she?
Yeah, she was living with Mum.
Well, it says at the foot of page 3, it had appeared that his daughter would not be admitted to Nigeria and her residence there would not affect her right to enter the Netherlands, so they appear to have been unfazed by the idea that the daughter would go to Nigeria.
So where do we see what was the contemplated outcome in terms of the disposition of the 3 members of the family?
Well, I think
Well,
the
it was
foot,
leaving it up to them, wasn't it?
foot of page 3, yes, leaving it up them.
So that was certainly a possibility. I mean,
That was the Dutch court.
well, yeah, when one talks about constructive deportation, perhaps a somewhat emotive term, one is actually talking, of course, about something that is going to be agreed to if it's going to happen at all. And whereas in the present case, this appeal, the tribunal had actually seen it originally as a choice as to what would happen. Now, it may be ultimately that wasn't really a viable choice, but one can have situations, of course, of choices, as in the Solomon case, it would appear. Oh, so you didn't.
Yes, thank you.
That I think, completes what I was going to say about the Strasbourg cases under this heading about the best interest of the child. I was going to now just invite the court to consider the core values of Article 8, the need always to bear those in mind. The core values are perhaps obvious. They're about being part of a family and developing relationships with others, but you do have that specifically mentioned, you may recall, in the Huang case. If I can just briefly take you back to that, it's it's tab 19 in bundle 1, where the committee looked at that at paragraph 18. It's paragraph 18 between letters F and G. The reported cases are of value in showing where, in many different factual situations, the Strasbourg court, as the ultimate guardian of convention rights, has drawn the line, thus guiding national authorities in making their own decisions. But the main importance of the case law is in illuminating the core value which Article 8 exists to protect. This is not perhaps hard to recognise. Human beings are social animals. They depend on others. Their family or extended family is the group on which many people most heavily depend, socially, emotionally, and often financially. There comes a point at which, for some, prolonged and unavoidable separation from this group seriously inhibits their ability to live full and fulfilling lives. So, important always to bear that in mind when arguments are made, in particular about the best interests of a child. We've already referred, as it were, in the course of discussion to the possibility of it being said, well, here is a child who's been in the United Kingdom for a very short period of time, family doesn't really have any connection with this country, but it would be in the child's best interest to stay here because of better schooling, better healthcare, better welfare provision generally. Well, that is not what Article 8 exists to protect, of course, and that must always be remembered. Hence, the need to consider the core values. And then very much linked to that, as I mentioned earlier, this principle that the Convention is not about preventing disparity in social welfare or other welfare provision. It is, of course, about civil and political rights, essentially, not about social and economic rights. You recall that point was made very strongly in the N case about the woman who would have to go back to Uganda who had HIV. We haven't got that case in the bundles, but my Lord Hope referred to the principle in the EM Lebanon case. If I can ask you to go to that, it's bundle 1, tab 23. EM Lebanon was the case about the woman and her young son who said that if they had to return to Lebanon, they would suffer a flagrant breach of their Article 8 rights. So it was a foreign Article 8 case. One issue that came up was the effect of the discriminatory legal system in the Lebanon, and it was in that context, I believe, that my Lord Hope referred to the N case. It's paragraphs 9 and 10, starting at page 936. Again, I'd be very grateful if the court would read those passages. It's beginning of paragraph 9 and then I think to halfway down in paragraph 10.
Yes.
And so we make the point that that general principle that your Lordship referred to there Convention is not about alleviating disparities in social welfare provision or healthcare, etc. That principle must be remembered in this kind of case also, which clearly suggests that in the hypothetical example we have referred to about the child with no real connection to this country who's been here a very short time, but who might on one view be better off, or perhaps on any view be better off here, that of itself will not give rise to an Article 8 claim. That if in such a situation there were an Article 8 claim, it would, we would suggest, be contrary to the principle that the Grand Chamber clearly supported and set out in the N case.
Yes.
That's pretty much it on the best interests of the child. I was just going to say a few words about the Secretary of State's policy. May I just have one moment?
Of course.
Well, the Court has already seen the guidance that has been issued under the 2009 Act. That's at tab 10 of Bundle 1. I should make it clear the Secretary of State accepts, takes the view that the guidance does indeed apply to all immigration decisions, i.e. all decisions that we are concerned with here, including the sort of decision that was taken in the appellant's case. And the policy, therefore, plainly is, as one sees from paragraph 2.7 that we looked at yesterday, that the best interest of the child is indeed a primary consideration, although there are others.
Yes.
And one needs to also be aware of the asylum and policy instruction under Article 8, which you have at tab 11, which also makes that point. If you go to the second page, headed Introduction, it says, this asylum instruction provides guidance on how to assess human rights claims under Article 8. And if you go towards the bottom of the page, the bullet points made there, our statutory duty to children includes the need to demonstrate, second point, the child's interests being made a primary, although not the only consideration.
So this is asylum, is it?
Yes, they're called that, my lord, but in fact, as one sees from the heading on the very first page and also the first sentence of the introduction, it's about Article 8.
Yes. Is there anything more in this document we need to be aware
I
of?
don't believe so, my lord.
Thank you.
I will come back, if I may, right at the end to what we say about the procedure more generally, the issues that Ms. Dodson dealt with in particular.
Yes.
Moving on then to the business of British citizenship and its relevance. I know the Court has a core proposition on that, certainly relevant, but weight will depend on all the individual facts of any one case. We have dealt with the domestic cases that have touched on, although certainly not fully explored this issue, in our printed case. And if I may, I will largely leave those to the printed case. It's paragraphs 33 to 37 of the case. But looking at the Strasbourg cases, I'm afraid I will invite you for the last time to go back to UNA. It's Bundle 2, tab 54. We emphasize, of course, that the applicant's partner and children in Una had Dutch nationality, but that was not regarded as a particularly significant factor in the proportionality determination. Your Lordships and Ladeship have seen from paragraph 57 and page 15 that one of the many factors listed was the nationalities of the various persons concerned. And you then see how that played in the court's consideration of the facts at paragraph 64. The court concurs with the Chamber in its finding that at the time the exclusion order became final, the applicant's children were still very young, 6 and 1.5 years old respectively, and thus of an adaptable age. Given that they had Dutch nationality, they would, if they followed their father to Turkey, be able to return to the Netherlands regularly to visit other family members residing there. Even though it would not wish to underestimate the practical difficulties entailed for his Dutch partner in following the applicant to Turkey, the court considers that in the particular circumstances of the case, the family's interests were outweighed by the other considerations set out above. In this case, the criminality of the applicant. So, interesting that here, the Dutch citizenship seems, in a way, to have pointed in favour of or towards the proportionality of removal on the assumption that even if the partner and children went to Turkey, the children would actually be able to go back to the Netherlands regularly to visit family members there.
One can see the line of thought from paragraph 58, which I think is drawing on the abortive judgment. And it's point 1, isn't it, there, that they are casting their mind over the seriousness of difficulties if the applicant, or the children rather, are moved to the country to which the applicant is to be expelled.
Yes.
So, I mean, that's assuming that there's no primary, or as it were, overwhelming objection to that happening in the first place.
Absolutely, yes.
I think that must be right.
Yes, that is right. And of course, it is of some interest that this case is always cited as the one that emphasises the best interests of the children, which it certainly brings out in paragraph 58, but one doesn't at this stage get the court referring to Article 3.1 of the Rights of the Child Convention or saying this is a particularly significant or primary factor. But anyhow, clearly there is an emphasis on the need to take those interests into account. There is another case that we have referred to in our printed case, Belle Judy and France. Maybe worth quickly looking at that too. It's tab 46. That was about the deportation of an applicant who had again committed various criminal offences. He was going to go to Algeria, and that was held to be in breach of Article 8 because it might imperil his marriage to a French woman. What we ask you to note is simply that there is no particular emphasis here on the nationality of the wife. It is a factor that was considered among others. It's paragraphs 77 to 79, starting at page 833. Again, perhaps I may invite the court to read those paragraphs.
Sorry, I haven't
Oh,
found the
this is
page
the
yet.
awful case in which he'd lost his French nationality because his parents hadn't
Yes,
registered.
had failed to make a
I mean,
declaration.
really. Such an extraordinary case, really.
No children, I don't.
No.
No,
Could you give me the page number again? I haven't
it's
found.
page
Is it
833.
833, yep,
Yeah.
thank you. Yes, and it was paragraph,
77 to 79.
right, thank you. Yes, thank you.
Clearly, there's a reference to his wife being French. For example, 78, Mrs. Beljoudi, for her part, was born in France of French parents, has always lived there, and has French nationality. But it's linked to other factors, such as, perhaps not surprisingly, she's lived there. She was born there, etc. So it's part of the picture. That then brings me to those two commission cases that I mentioned. They are in the separate bundle with a little note from us at the front.
Now, is it in? This is in the white file, is it?
This is in the file, yes.
Yeah.
It's a case, first of all, called O&OL against the United Kingdom, which should be in tab 5 in that file. And I'm afraid the page references in the note have turned out to be wrong because of the particular printout that then found its way into the file. I'm sorry about that. Now, that's the commission in 1987, looking at, as one sees from the first page under the heading The Facts, two applicants who were brothers. They are British citizens by virtue of their birth in the United Kingdom, which was the basis on which at that point they were able to acquire citizenship, whilst their parents, Turkish Cypriots, were in the United Kingdom. And there's a long and convoluted history as to what happened to the parents and their various attempts to come to the United Kingdom and stay here. But if you look at the heading Complaints on page 4, you see that the two brothers complained that the deportation of their parents to northern Cyprus constituted a breach of Articles 8 and 13. The applicants contend that as regards Article 8, the interference with the family's rights cannot be justified in the case of children who have the right of abode in a particular country, who have substantial links with that country, and who are no longer of such adaptable age or disposition that it could be reasonable to expect them to follow their parents elsewhere. And one sees, if you go over the page, second paragraph, first sentence, furthermore, it is claimed that the applicant's education will be very seriously affected if they follow their parents to northern Cyprus. And jumping to the beginning of the next paragraph, the applicants submit that in all the circumstances it would be unreasonable to expect them to follow their parents by reason of their upbringing and different social and cultural background. And right at the end of that paragraph, although it is necessary to maintain even-handed immigration controls, the applicants emphasise the particular circumstances of their case, its negligible impact on immigration controls and its rarity, given the impossibility nowadays for children of foreign parents to acquire British nationality by virtue of their birth in the United Kingdom. And at the bottom of the page, the Commission starts looking at the law. Over the page, page 6, if you go to the third paragraph, they say, in the present case, the Commission first notes that the applicant's British nationality is exclusively based on the fact that they were born in the United Kingdom. However, this fact alone cannot confer rights of abode in that country upon the parents, particularly when, as in the case of the second applicant, the birth occurred whilst the parents had no right to reside in the United Kingdom. And then there's, of course, more reasoning, but if one goes straight to the end, really, it's the paragraph beginning, thus, while the Commission considers, still on the same page, the end of that paragraph, in such circumstances the Commission finds it compatible with Article 8 to expect the children of unlawful overstayers to follow the parents, even if those children have acquired theoretical rights of abode in the deporting country. So
What was the date of this?
That's 13th of July 87. You then have a somewhat more recent one called Sarabji at the previous tab, actually, tab 4. Again, it's the Commission, and one sees from the top 23rd of October 1995. And in that case, the complaint was made by the 3-year-old daughter of a Kenyan mother. The daughter was a British citizen. And one sees that, of course, under the heading of the facts on the first page. And the complaint that is recorded at page 2 towards the bottom, the applicant complains that the decision to remove her mother, or first constitute inhuman and degrading treatment contrary to Article 3, but then over the page, second paragraph, the applicant invokes Article 8 of the Convention in respect of the removal. She submits she's lived with her mother in the United Kingdom since her birth. Her British citizenship derives from her birth to a British national father who's acquired his nationality by birth, not dependent on the fact that she happened to be born on British soil. Her mother would have qualified as resident as spouse of a British citizen, but she didn't complete the necessary formalities while the marriage subsisted. The removal will exclude her from enjoying the health, education and welfare benefits to which she has a right as a British citizen, and also from forming any contact with her father at a later stage. The decision faced her with the option of remaining in the UK, probably in local authority care, to avail of her rights as a British citizen, or the option of accompanying her mother to Kenya, where she will be unable to enter mainstream society and sacrificing her private life right to grow up in the United Kingdom. So all of those points are put, and then at page 6, one sees how the Commission rejects those arguments. And I would highlight in particular, of course, I invite the Court to read the whole of the reasoning, but highlighting the second paragraph on page 6, in answer to the claim that it's reasonable to expect the applicant to follow her mother, it should probably be not reasonable to expect the applicant to follow her mother, and that she is of an adaptable age. I'm sorry, no, I misread it again.
Yes.
The applicant argues that the question is rather whether it's reasonable for a contracting state to expect its own citizen children who've acquired that citizenship otherwise than by an accident of geography to live in prolonged exile from the country of citizenship because of the irregular immigration position of the one parent who happens to have custody of them. And then if you go right to the bottom of the page, while the applicant has argued that weight should be given to her British citizenship, the Commission notes that in previous cases the factor of the citizenship has not been considered of particular significance. And then there's a reference to the case we just looked at. And over the page, while, as the applicant points out, the children in that case, in the OL case, had obtained British citizenship by use solely, whereas she derived her citizenship by use sanguinis through her British father, the Commission does not find that to be a material distinction, where the child nonetheless is of an adaptable age and there are no effective obstacles to her accompanying her mother. As regards the problems with respect to possible shortcomings in healthcare in Kenya, these are not, in the Commission's view, of such a nature or degree as to impinge on respect for family or private life. The Commission finds there are no elements concerning respect for family or private life which in this case outweigh the valid considerations relating to the proper enforcement of immigration controls. No breach of Article 8. Now, of course, we accept that those are decisions of the Commission and not the Court, and they are not particularly recent, but we would say that the reasoning is consistent with the reasoning you get in subsequent cases, in the sense that, as we've seen, those cases do not put a premium on nationality.
Have they been picked up in footnotes in any decisions of the Court, as far as you're aware?
I cannot think of them having been picked up in a Strasbourg court decision. The Sorabji case is picked up in a Court of Appeal decision that I actually wasn't going to take you to, but you do have it in the bundle. It's called Gangadine.
I mean, one sees Mr. Bratz, as he then was the UK member of the
Yeah.
Commission, and as one knows, I mean, they pay particular heed to the judge of the national.
In Gangadine, the reference is page 784.
Sorry, which tab?
Tab 1.
That's tab 1.
I think
What
the
is the
page,
same bundle?
yes.
Same bundle, yes.
Sorry.
Page numbers are a little difficult to follow. It's 784, is it? It's from...
Yes, it's
The family law
last
report.
paragraph, a substantive paragraph, just above letter E.
Well, it's just the page numbers have been missed up. The,
Yeah, we haven't
the
got
corner.
those now.
Top left-hand corner, page 784.
Well, we don't have top.
Oh, you don't?
That's the
Well-
problem. It's
Oh,
just
I'm
the
so sorry.
photocopying.
I'm sorry, they must have... Oh, dear. The last page,
784 is the last page.
last
Oh, well,
page
that's
in the
all
clip.
Ah.
I'm sorry about the poor copy.
Oh, yes, I found it. It's in Swinton Thomas's
That's right.
judgment, yes. Yes.
Well, this is only a 1997 decision itself.
Yes, that is right.
And it looks as if nobody has looked at the convention. Which,
well,
at
no,
that
but-
stage, of course,
The convention was actually looked at.
Was it?
Yes, but it was, of course, before it was introduced through the Human Rights Act. If you go to, well, in my copy, it was actually 782.
forgive me, I was looking at the UN convention.
Oh, I'm so sorry.
I think there's no reference to the UN Convention.
No, I think that's right. Yeah.
Well, wait a minute. What
It's
about
got- there's a reference to-
771 between D and E?
771?
I seem to have that page number on by chance.
Oh, sorry.
I am very grateful and I apologise. I had entirely missed that.
Seven seven one
The
is
UK's
about,
reservation.
yeah.
Yeah.
Yeah, that's the letter E.
Those have been withdrawn
Yes,
Yes.
that's right.
last recently.
And I hope to be able to put before the court, although I can't do so just this minute, but such documentation as there is to show the terms of the withdrawal of reservation.
So what is it? Gangrene?
Gangadine.
Yes.
Now, yes, it doesn't appear, so far as we have been able to make out, that this particular point has been argued subsequently. So these two commission decisions are as close as we've been able to get to the argument actually being put very specifically about nationality. So it may be, of course, that is why those decisions don't appear to have been referred to in subsequent decisions of the court. So far as the domestic cases are concerned, I was only going to touch on the M and Islington case, which Mr. Gill did place particular emphasis on. I think he took the references from his printed case, but you have it at bundle 1, tab 28. And the appellant relied, of course, on some dicta by Lord Justice Buxton, obiter dicta, but he was concerned that the British nationality of the child in that case might be of relevance. And really, I wanted to show you that that was the concern, as opposed to a specific concern that the British nationality of the child would be a particularly important factor. He was concerned that it shouldn't be ignored as a factor. If one goes to paragraph 27, one gets that point. He's referred in paragraph 26. I'm sorry, this is page 896.
Yeah.
He's referred at 26 to the Irish Supreme Court case of Lobey, where there had been arguments about whether a child is effectively able to exercise a right of citizenship, and the whole case was about the consequences of Irish citizenship. It wasn't about Article 8. And the view had been expressed, particularly by Chief Justice Keane, that a minor child couldn't really exercise that right. So at the beginning of paragraph 27, you then have Lord Justice Buxton saying, if that authority can be applied in our case, then the status of the child as a British citizen becomes effectively irrelevant. I would wish to approach that proposition with caution. Now, as I've said, we of course don't contend that it's irrelevant, so Lord Justice Buxton needn't worry on that score. And of some significance, one sees at paragraph 24, starting at letter D, he makes two comments about Article 8. He says, two comments are necessary. And that's really in response, I should say, to the Secretary of State's submission that is recorded at the beginning of paragraph 24, and where it said the child's citizenship would be a factor to be put into that balance. Lord Justice Buxton then says two comments are necessary. First, it is established convention jurisprudence that Article 8, nor any other article of the Convention, does not create a direct right to enter or remain in any particular country. And then it's therefore difficult to see how the child's right of abode could play an independent role in any Article 8 assessment. Second, if, as Islington concluded in the present case, family life can be reproduced in the country of removal, then it's difficult to see how the case could fall under Article 8 at all, because, as made clear in Mahmood, Article 8 creates no right to enjoy family life in one country rather than another. What we fasten on is really the reference at E to how it's difficult to see how the child's right of abode could play an independent role in any Article 8 assessment. Well, as I keep saying, we accept it has a role, but that is really what it is, depending on the circumstances. We come back to the point I sought to make yesterday, that of course there may be many other factors equally important or even more important. And you could ask, well, to what extent is it warranted to elevate British citizenship when in fact someone who is settled with indefinite leave to remain will also be able to enjoy many of the benefits of citizenship, such as entitlement to welfare benefits, entitlement to work without restriction, entitlement to be in the United Kingdom.
But I mean, there is some Article 8 aspect of identity and all this sort of stuff, isn't there? I mean, I don't think you can't ignore it. I mean, no doubt it's got shifting weight, but it's there, and the fact that you don't have that same identity wherever else it might be contemplated you'd go.
Well, you'd still retain your British identity.
But whether you can realise it in quite the same way is another matter.
But, my lord, I mustn't be seen to be in any way suggesting it isn't a fact.
No, I mean, I don't, but I think perhaps Lord Justice Buxton put it a bit low there. Indeed, he seems to have ignored it entirely.
Well, looking at paragraph 28, I think what had happened in the case was that there hadn't really been an assessment of the implications at all. Is that right? And it was to go back to the tribunal for further examination. So it may be there wasn't much of a focus on the detail.
Yeah, that's my understanding.
I think that may be the problem there.
And his concern then about the implications of Lobey, etc., That's caused him to make the comments he made, and that has then been fastened on by the appellant in particular in this case to mount the argument, which after all was the argument in the Court of Appeal, that effectively British citizenship is a trump card, which will trump all others inevitably. And that argument was rejected, of course, by the Court of Appeal. As we would say, it had to be on the authorities, and of course the appellant hasn't put it as highly as that before this court. And here too, when we look at the relevance of this factor, one comes back to the need to bear in mind the core values of Article 8. Again, not suggesting citizenship doesn't come into it, but we are essentially concerned in these cases, usually with family life, and even if it's private life, it's the ability to create and maintain relationships with others that is at the heart of it. And we are not concerned with welfare protection, so to the extent that one says, well, you have all these benefits of being a British citizen. Yes, you do, but you must then be careful that you don't allow a concern about that to then turn it really into a situation where you say, well, because of those benefits, inevitably say a very young child must be able to stay here with his or her family. Of course, the child will be entitled to stay here because of British citizenship. But again, you have that factor. Could it really be said that you could never deport or remove the family because it might have the consequence that a young British citizen child would have to move with the family? And the answer is no. In fact, the answer given by my Lady Baroness Hale in the Nidiker case.
I mean, what happens if it's a family and they're going back to, I use sub-Saharan Africa only because of the N case, not the rest of it, but and the family say to themselves, well, here is my 1-year-old child, and it's entitled to stay here, and actually, I think it would be better for it to leave it behind. Now, what happens to a child like that? It goes into what, care, or goes into care?
Looked after by the local authority, yes.
Looked after by the local
That's
authority.
how I would understand it, yes.
But I mean, but if that then becomes a sort of a realistic possibility that actually might happen, because of all the welfare benefits, all the economic and social and health, educational attractions of that. I mean, at that point, presumably, I mean, all those considerations do begin to sound under Article 8, don't they?
Well, my lord, they sound under Article 8 in any event, in the sense that they have some relevance, because you look at whether it would be reasonable to expect the family life to be enjoyed elsewhere. And one factor, no doubt, that comes into it is then that the child is British and would have those benefits if here. But you still put that into the pot together with all the other considerations. Now, if the choice is made that the child should stay here because of its right to do so, well, that is the right and privilege of the child, as it were. But no, in answer to your lordship's question, that does not change the fundamental Article 8 analysis under which you weigh up all the factors. One comes back again to the possibility of a child whose family really has very little connection with this country, but still becomes British citizen. One might say it must have some connection if it manages to become a British citizen, but let's say that overall there are very strong connections, at least, with another country, and the child has been here for a very short period of time. Well, it's not going to be inevitably disproportionate to remove in that case, even if it does mean that the child goes with the family.
Or is left behind.
Or is left behind, if that is the decision that is considered right by the family. Yeah. Finally, under this heading, a few words about the Chen case, not least because I'm concerned that it was put to me yesterday, as I understood the comment by my Lord Mance, that really we're concerned here in Chen with persons who move from one EU country to another. And in a broad sense, of course, that's absolutely what Chen is about. It is about free movement rights, as they're generally called. But to be accurate, one needs to bear in mind that there isn't actually a requirement for a person to have physically moved from one EU country to another in order to be able to assert those rights. It is sufficient if you are a resident in another EU member state other than the one of which you are a national. So if you're Italian and you're born in Germany, you can exercise free movement and residence rights even though you've never actually moved from Italy to Germany. So I just wanted to make that clear.
Yes. You do have to have some cross-border.
Oh, absolutely. You have to have a foreign cross-border element. So going back to the point I understood my Lord Brown to make, you can't simply say, well, I should have an EU right because I live in the EU.
Yes.
You have to have,
It's made clear in the decision you don't actually have to physically move.
No, quite.
Given those primary facts.
That's right. That's actually in the court's judgment, paragraphs 18 to 19.
Yes.
What was the reference to Chen?
Chen
It's
is
359.
59, indeed.
Thank you.
The paragraph numbers you gave?
18 to 19.
Thank you.
And it's also in the Advocate General's opinion, paragraphs 30 to 32. And perhaps I should also just pick up the reference to Article 8 in the Advocate General's opinion. That's paragraph 94, where...
Yes, I think we saw that
page
yesterday.
338.
Yeah.
Well, he makes the point that if the mother weren't able to reside with the daughter in that case, then that denial, he says in paragraph 94, would contravene the principle of respect for the unity of family life as laid down by Article 8. Now, one needs to be aware here before one immediately says, oh, well, in that case, it follows that Article 8 demands always the same result as in Chen. One needs to be aware of the particular facts here, which one gets conveniently from the court's judgment, paragraph 13 on page 346, where the court says that the order for reference also makes it clear that Catherine is dependent both emotionally and financially on her mother.
Sorry, paragraph what?
13.
1-3, thank you.
Page 346. That her mother is her primary carer, that Catherine receives private medical services and childcare services in return for payment in the United Kingdom, that she lost the right to acquire Chinese nationality by virtue of having been born in Northern Ireland, and her subsequent acquisition of Irish nationality, and as a result, that she only has the right to enter Chinese territory under a visa allowing residence for a maximum of 30 days per visit. So she really didn't have the option to go to China and be there with her parents. But the court has our key point here that this is all about the consequences that flow from a particular status as a matter of EU law, particular free movement rights, and you simply cannot read across that the outcome of this case on the facts would have to be replicated in Article 8. There is a certain reading across, of course, as we see from the Advocate General, between the Convention and EU law, but it doesn't follow that Article 8 reflects the EU law rights, obviously not. My Lords, those are our submissions on citizenship, unless I can assist in any other way. So far as equality is concerned, I've really made the point that we say as strongly as we can. It really isn't on the menu of issues. If Article 14 was something that the appellant wanted to raise. She really should have raised it some time ago, but certainly at the latest in the statement of facts and issues, nor has the appellant, so far as I can make out, identified any particular provision of domestic anti-discrimination law that could be or that is invoked. The main point on equality seems to be that children have equal rights with adults, which of course is somewhat contrary to the submission that children should be given particular consideration and that their rights are more important than anyone else's. So we say that argument really doesn't take the appellant further, but my primary point is that it, as I say, it really isn't on the menu. So far as representation of the children is concerned,
Are you
yeah.
going to include in this chapter taking the views of the children?
yes.
You are,
Yes, sorry, I was going to, yes. Of course, Ms. Dodson is very helpfully here in this important case, and we raise no objection to that. But looking now at representation, first of all, as we say in our printed case, well, we remind the court really of what was said in EM Lebanon. If I can go back to that briefly, that's Bundle 1, tab 23, where the point was made that in Article 8 cases, one should really rarely require separate representation of the children. Certainly their rights must be given separate consideration, but that's a different point. If I may go to paragraphs 48 and 49 of my Lady Baroness Hale's speech, starting at page 951. It has been a great help to be able to consider this case from the child's point of view. In the oral hearing where we considered the child's application to intervene, the Secretary of State acknowledged that the child might have a separate Article 8 claim of his own. Our recent decisions in Bioku Betts and Chikwamba have made it clear that not only the Secretary of State, but also the Tribunal must take account of the Article 8 rights of all those who are affected by their decision. This means, as Lord Bingham says in paragraph 43, that they call for separate consideration. Separate consideration and separate representation are, however, two different things. Questions may have to be asked about the situation of other family members, especially children, and about their views. It cannot be assumed that the interests of all the family members are identical. In particular, a child is not to be held responsible for the moral failures of either of his parents. Sometimes further information may be required if the Child and Family Court Advisory and Support Service, if CAFCAS or more probably the local Children's Services Authority can be persuaded to help in difficult cases, then so much the better. But in most immigration situations, unlike many ordinary abduction cases, the interests of different family members are unlikely to be in conflict with one another. Separate legal or other representation will rarely be called for. And if one turns to Lord Bingham's speech, paragraph 43, page 950, the Court of Appeal and the courts below were disadvantaged by the absence of representations on behalf of AF, the child. The hearing before the House has underscored the importance of ascertaining and communicating to the court the views of a child such as AF. In the great majority of cases, the interests of the child, although calling for separate consideration, are unlikely to differ from those of an applicant parent. If there is a genuine conflict, separate representation may be called for, but advisers should not be astute to detect a conflict where the interests of parent and child are essentially congruent. And we respectfully submit that all of that is right and should guide the court, the tribunal, and decision makers in this area, and is entirely consistent with Article 12 of the Convention on the Rights of the Child. If one goes back to that convention one last time, it's Bundle 2, tab 43, Article 12. provides at page 4, states parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. For this purpose, the child shall in particular be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child, either directly or through a representative or an appropriate body, in a manner consistent with the procedural rules of national law. So the point, of course, is made is that the child can be heard through someone else, and therefore we would say can be heard through a parent, where there's no conflict at any rate, or in an appropriate case where that is required, through separate representation. And that can be the position at any stage of the process, including, we would suggest, at the earliest stage where the decision maker, the original decision maker, seeks to ascertain the position, all the facts, etc. May I just have one moment, Final? Yes. Now, what I have just said is also consistent with the committee's general comment 12 about this particular topic. That's bundle 3, tab 63, paragraph 36. So, the committee's comment on the right of the child to be heard. Paragraph 36 on page 12. Paragraph 35, after the child has decided to be heard, he or she will have to decide how to be heard, either directly or through a representative or appropriate body. The committee recommends that wherever possible the child must be given the opportunity to be directly heard in any proceedings, but then the representative can be the parents, a lawyer or another person, inter alia a social worker. And then the reference to the possibility of conflict of interest.
Well, it's a rather strong reference, isn't it?
Yes.
It must be stressed that in many cases there are risks of a conflict of interest between the child and their most obvious representative.
Yes. And
so it's not enough just to say, oh, well, the interests of the children and this parent are identical, we'll just take the parent's word for what the children think.
Well, of course, it depends on the circumstances. I mean, this is a general statement that, of course, doesn't focus particularly on the situation we are concerned with, where I would suggest it was rightly observed in EM Lebanon that actually, in most cases of this kind, it's unlikely that there will be a conflict. And if I may say so, in relation to the observation about not visiting the sins of the fathers upon the children, of course, even in a case where the parents have a bad immigration history and have sinned, if you like, in that way, the interests of the children may well fit perfectly well with the interests of the parents, even so. It's not obvious to us how the fact that the sins of the parents shouldn't be visited on the children as a proposition really means that there's likely to be a conflict. As take this case, for example, appalling immigration history of the appellant, but the interests of the whole family would appear to be the same. And of course, if there's a problem about the parents lacking credibility, it's perfectly possible for children to be called to give evidence, provide a statement to a tribunal. So that
this raises a question, as when it talks about being heard, is it contemplating that this will always be orally, or does it include the provision of views in writing?
in Article 12?
Yeah, in this discussion.
Well, I would suggest that it must surely contemplate being heard in writing potentially. I mean, first of all, it clearly contemplates being heard not just directly but indirectly through a representative.
Yes. Well, there are obviously various ways in which views can be transmitted,
Yes.
to pick up a word
And
in
it
the
would
middle
be-
of paragraph 36. So
Yeah.
this guidance can apply to the transmission of views by way of a statement.
Yes, I would
which-
suggest that must be so, and that would be the only sensible interpretation. Certainly if you can say the views can be heard through a legal representative, which is clearly contemplated, it must be acceptable for those views. A legal representative would, depending on the circumstances, or might be able to put forward views in writing. It'd be very surprising if those views would not then be the views of the child through that legal representative, albeit, as it were, indirectly, not orally directly from the child, or not in writing directly from the child.
I mean, this is true. This, on a worldwide basis, the administrative bodies, I mean, a lot of them work entirely on the document.
Yes, and of course one knows that in other countries there's far less of a tradition of oral submissions anyhow in judicial proceedings too. So it would be, I would suggest that it would surely have been made express if it really were intended to say that communications in writing would not be good enough, and it frankly would make a system very, very difficult to operate.
Very often it wouldn't be in the interest of the child to require the child to come and address a court. It's far better in most circumstances if some responsible person can take his or her views in an informal setting, relay those to the court.
Indeed, yes.
Now, if we're contemplating that, which for myself I'm very happy to do, at what point in your submission does this take place? There has to be contact then by a responsible representative with the child, so that the child's views can be directly communicated through that representative in writing.
My Lord, can I make it clear? I don't have the requisite instructions to say that would be something that those instructing me would say was sensible and the right answer. So I'm afraid the only way I can assist the court at this stage is by saying that these provisions clearly contemplate that the child's views can be heard in various ways. And so we would say, if you look at the system as it operates now, certainly it's open to parents, and they do communicate the perspective of a child in their written communications with the Secretary of State. Their lawyers may do so, and the children's views may be communicated in different ways at different stages. For example, in this case, and this is really picking up a point made by Ms. Dodson yesterday, certainly there was a specific report dealing with the children at the level of the tribunal, which you have starting at page 99 of the appendix. And that's from a children and families worker who says she's been working personally with the children for more than a year. That's first page of the report, page 99. And without going into the report in detail, she then makes various references to the children. So that's one way in which it could be done. But
Isn't there a
yeah.
problem at an earlier stage, or a point at an earlier stage? Those who are instructing you, the Secretary of State, is responsible for issuing the original determination letter.
Yes, indeed.
And at that stage, your Secretary of State's, the Home Office's duty, the Border and Immigration Agency's duty is presumably to have regard to the human rights of those affected, because it's a human
Indeed.
rights application.
Indeed, absolutely.
And so at that stage, surely it's incumbent on someone to ascertain the views of the child, if it makes sense, if the child is capable of having views, I suppose. And I'm not sure there wouldn't be some obligation on the Secretary of State to inquire, wouldn't there, as to what the views of the child were. No, not directly. I mean, ask for a statement from the applicant, who is presumably best placed to know.
Well, certainly there needs to be clearly sufficient information to carry out the duty of evaluating all the rights of all the relevant family members, and indeed to look at the best interests of the child and to weigh all the relevant factors, absolutely. Now, as to precisely how that information is gained at that stage, I would say, and I'm afraid that's all I can say at this stage, because in the time available it's not, I'm afraid, been possible to get into it in greater detail, it is that the views can be communicated through the parents or through whatever legal representative communicates in writing, usually, with the Secretary of State.
Presumably, in most cases, it's likely to be fairly obvious. In other words,
Yes.
the applicant's letter will simply say, we've ascertained that our client has spoken to the child, or maybe we've spoken direct, and we are confident that the child supports the mother's view. Or
and of course, if there's a lack of clarity, further questions can be asked. And if it appears that there is a conflict of interest, well, that's something that can then be considered.
Yes, I think you did say the picture could change at different stages in the process, assuming that there are, as in this case, a whole series of determinations of one kind or another. So this is something that has to be kept in mind at each stage, then, would it be?
Yes. Yes, it would seem to me that it would have to be taken into account at each stage. Yes. But of course, I'm not suggesting thereby that one, I should make it clear, that one needs to have a meeting with the child at the first stage, or indeed necessarily at any stage, or a separate person representing the child. That would have very obvious resource implications apart from anything else, and I'm afraid I'm simply not in a position to spell out the details of what might happen in any particular case, save to say that.
Thank you very much.
May I just have one moment? Okay. My Lord, yes, those are our submissions. I'm told that if we are able to obtain any further information relevant to this last topic, we might perhaps be able to convey it after lunch. If it is truly relevant, I may seek your indulgence to do that, but as to that, we don't know. I am told, a document that shows the withdrawal of the reservation. So if I may hand that up.
Thank you very much. Yes.
So what is this?
This is the reservation to the Convention on the Rights of the Child.
Oh, yes.
A notification, I think it is, to the UN Secretary General showing that the reservation is being withdrawn. Right. Yes, it's right at the end. One gets it, page 37 of 37.
Hello, page 37. Doesn't look as though it leaps off the page.
Yes, indeed.
It's rather small print.
It is.
But you believe it's there somewhere, do you?
Oh, yes. I do believe the text is there, right at the end.
It's right at the end.
Ah,
Yeah.
right.
Right at the end,
Yes, thank
and it sets out the text of the reservation. Yes, and I'm also reminded, I'm very grateful to my Junior, I think I mentioned that we had copies of the Wan case, which was referred to in Miss McAdam's article.
Oh, yes.
This is the Federal Court of Australia. I
Yes.
probably don't need to take up time now to refer to it particularly, but it has the quotation that Miss McAdam makes in her article.
It's very long.
Because the interesting thing about the reservation, when one looks at it,
Yeah.
is that it was reserving the UK's right to have laws affecting people without the right to be here.
Yes.
Yes. And that has been withdrawn. And one can understand that that leads to Section 55. Of course, we are here concerned, as we keep on saying, with people who do have the right to be here. And you could argue, could you not, that therefore, in decisions affecting them, the reservation did not apply in any event.
Happily, I don't have to grapple with that argument, which is very lucky for me. But yes, and we are, of course, concerned with both, but children and mother, yes. That really is it then, thank you. Subject to any questions?
No, I don't think so. Thank you very much indeed. Miss Chan, do you wish to add anything? Thank you. Now, Ms. Dodson, we don't take a reply from interveners, but we're very grateful indeed for the note which you've supplied us with on your behalf, which gives us some very useful information. Thank you very much indeed. Now, Mr. Singh.
I was just
Mr.
wondering.
Gill, I beg your pardon. Yes.
I was just wondering if, I'm sorry, having
Yes.
looked at this note, Mr. Singh, if you'll forgive me, if I could just ask Miss Cass-Frisk. There's some very useful information in
Yes.
this note from paragraph 5 onwards.
Paragraph 5 onwards.
Yes.
Yeah.
In the intervener's note about an early. Oh yes, it's the second paragraph 5.
Yeah.
It's about the border agency's intention to run a scheme called Early Legal Advice Project, ELAP. And in paragraph 7 it goes on to say that the interveners submit that ELAP provides a framework whereby the Borders Agency's commitment to children in Section 55 can be achieved in practice, because the scheme could enable those children whose rights are affected either directly or indirectly to have their circumstances fully and professionally assessed. Now, I should have put this to you earlier, because you're in a position, or those instructing you are in a position to know whether that is a realistic suggestion or whether it isn't.
Yes. My lady, I'm afraid I haven't had a chance myself, and I don't think those instructing me to digest this note yet. That's not a complaint, but we got it only just before we started this morning, so may I take that away?
Just as a way of dealing with this, that we're approaching the short adjournment.
Yes.
You might like to take instructions after that, and if Mr. Gill doesn't mind, we would receive any comments you'd like to make after the short adjournment. Would that be acceptable?
Yes, indeed. I will certainly try and hope that I will be in a position to do so, of course.
Thank you very much. Sorry, no, that's fine. Mr. Gill.
My Lord, in dealing with the meaning of Article 3, I ought to draw to the Court's attention the documents that the Court asked for, which are the Alston Articles.
The what?
The articles by Philip Alston.
Yes, yes.
If perhaps the extra bundles can be handed up to you. It may be that some of the materials in these bundles are not all going to be necessary, bearing in mind the submissions that we've heard. But it follows on from the two documents, the Tobin article and M versus the state, that you already have. So what we've done is to provide tabs after that as well.
Yes, thank you.
And there is, I hope, helpfully an index.
Yes.
The slight disadvantage is that although these articles come at tab 98 to 99, and they're the two that are cited in the McAdam article. The one at 98, because I think it was faxed from Mr. Alston's university itself late at night.
It's not terribly easy to read.
It hasn't come out terribly well.
Yes.
If we can try to get a better copy from him, we'll do that, but it may be that the more important parts rather, which are the parts which go from page 7 on Article 3, that the bulk of that can be
A certain amount of guesswork is required. Various points. Are there particular passages that you've identified that we should be concentrating on?
Well, it is. If we go to the section on Article 3, what he says is that having set out in the second paragraph, the use in Article 3, however, is of paramount importance since it's an umbrella provision. And then he goes on to say, the bottom of page 7, penultimate paragraph, simply by using the phrase, the drafters of the convention were not breaking any new ground, what he's signalling there is that they were having regard to the 1959 declaration, which he refers to, and then he goes on over the page to then say the principle has been criticised by scholars because it's open-ended and indeterminate, and that's the point, critical point about giving it some content. And then he begins to talk about the drafting history at the bottom of page 8. And that's, he's beginning to equate it to the approach in the 59 declaration where the word paramount was used, but to recognise, as is clear from the top of page 9, that the words a primary were used to ensure a sufficient flexibility, at least in extreme cases, to enable the interests of people other than children to prevail. And then he mentions the point about the burden of proof, which appears elsewhere as well, and we say also appears in Article 8 to itself. Without straining, it's difficult to be clear about the rest. But the subsequent article at tab 99 is beautifully printed, and that at page 2, under heading 2, begins to deal with Article 3.1 in its broader context. And again, he's basically on page 3 going through the sort of points that we've already been through, and on page 4, ICCPR, African Charter, and so on. And he, I think there's something on the drafting history in this document as well, but if I can, yes, it's at page 10. This is rather more detail on the drafting history. It's to a large extent consistent with what you saw in Professor Freeman's text.
Yes.
And middle of the page in particular, on page 10.
How do you relate the interests of a child to other interests, an adult's interests? Does one say that, I mean, one would like to say that they were both paramount. If it came to the crunch, would you say that children's interests are more important than adults' interests? Is this an entirely fruitless question?
If it came to the crunch, I would say yes, they are. Because they are vulnerable individuals to whom specific duties are owed. International conventions place those duties on a higher footing. Well, higher footing is perhaps the wrong phrase. They require more to be done by states to actually achieve the realization of those interests. And that is why they have to be kept at the forefront. They're the first consideration.
The difficulty is that sort of comparison seems to ignore the possible different weights which children's interests or adults' interests may have in particular cases. Sometimes what the children's interest may be relatively slight, one does something, and yet and an adult's interest may be extremely potent. So
Well,
I suspect it's a fruitless inquiry, really, but...
Well, I suppose you have to... the point about the autonomy of the individual is of particular importance, I think. And what comes through in all of these texts is that you've got to treat the child as an autonomous individual. And in making the assessment of the best interests of the child, you've got to have regard for that. So even if it were to be the case that it may look on perhaps a traditional approach that the adult has interests which ought to override a child's, if one actually looks at the matter rather more through the child's eyes, one may actually begin to see that the best interest of the child, the relevant interest of the child in the particular case, does in fact acquire a potency which will override what would otherwise look to be a strong interest. I think I wasn't going to go through...
Well, can I just just draw your attention to pages 12 and 13, because he makes the point, which we've seen already before, that it depends a bit on what you're talking about. If you're dealing with custody decisions in domestic law, then, of course, it has very great potency. But then he goes on to say that the phrase in the article is dealing with a whole range of possible situations. And then he sees a bit at the top of page 13, which we're very familiar with now, I think, that there's a flexibility, particularly in extreme cases, or at least in extreme cases. And then the bit which I don't think Miss Carr-Frisk would really agree with, which is the burden of proof point, and the test of whether there are other feasible and acceptable alternatives.
Yes, we say all of that is consistent with, in fact, a proper analysis of the Strasbourg case law. But when you analyse it, whilst the Strasbourg case law repeats, as it does in order to ensure flexibility, that you have regard to everything, the reality, when you look at the result in each of those cases, is that normal immigration control, if I can put it that way, doesn't carry a bean. The real facet of immigration control that actually is regarded by Strasbourg as significant is actual direct threat to other individuals of society caused by criminality. In practice, that's what it comes to. Yes, you can say immigration control will always remain in the frame because, as we saw from paragraph 54 of UNA, they always start off by saying it's always the case that the state has the right to control its borders. Of course it does. That standard, of course it'll have a general right to do that.
I'm sorry, Mr. Gould, but I mean that simple illustration I put earlier this morning about the woman and her child coming in the back of a lorry and being found a month later. That's immigration control, pure and simple, to send them back. You say, however, that the interests of the child in remaining here trump that.
Well, you've got to first of all understand what the interests of the child are, and once you've understood what the best interests of the child are, if it requires the mother to remain, then to use the language of Trump, yes, it trumps.
Well, shall we continue the discussion
Yes.
at 2 o'clock?
Yep.